Good afternoon and welcome to this fraud sustainability seminar in section 187B, Planning Injunctions. My name is Mark O'Brien-O'Reilly and the purpose of today is twofold. First of all, it's to talk you through the mechanics of section 187B, look at the legislation and some of the recent case law, as well as talk about practical tips. The second purpose is to mark the launch of my recent book, called A Practical Guide to Injunctions pursuant to Section 187B, which was published in February this year. We had a book launch in Chambers a couple of months ago, and the purpose of today is to ensure that all those who perhaps missed that or who were affected by some of the technological difficulties we had that day are now able to hear some of the background publication of the book. And also, I should say that if you're interested in a hard copy of the book, it's available with a 10% discount code for attending today. And if you contact us in Chambers, we'll be able to provide that to you. So turning firstly to the legislative provisions. And what Section 187B of the 1990 Act tells us is that the local planning authority is afforded a power to seek an injunction to restrain breaches of planning control. And subsection 1 tells us that power can be exercised where it is considered necessary or expedient. And it can also be exercised in respect of any actual or apprehended breaches of planning control. And also the power can be exercised irrespective of whether or not the LPA have already proposed to exercise or have already sought to exercise any of their other enforcement powers under the Act. So it doesn't require you to first, for example, have issued an enforcement notice or a temporary stop notice. We'll talk in a moment about some of the factors the court may consider, which will include perhaps the expediency of other enforcement action. But in respect to the statutory provisions, it's quite clear there's no need to wait for other enforcement action to take place first. The other point is actual or apprehended breaches. So there's a distinction, of course, between an actual breach. So, for example, development has already occurred, and an apprehended breach, where the local planning authority considers that there's likely to be a breach of planning control. And one of the powers afforded by Section 187B is to seek an injunction even where a breach is just an apprehended one. So unlike, for example, the need to wait for a breach of planning control before you can serve an enforcement notice, Section 187B allows you to seek to try and get ahead of that apprehended breach before the harm has been realised. Subsection 2 affords the court a wide power to grant such injunction as it thinks appropriate. Rule 3 deals with the possibility of granting an injunction against persons unknown, and we'll address that later on in the webinar. While Section 4 provides that the power is afforded by the High Court or the County Court. The majority of applications will take place in the High Court, however, because where they involve an application for an interim injunction, which requires the application of what is known as the American Centimede principles, that will require the application to be made in the first instance to a High Court judge. So turning now to some of the purposes behind Section 187B, and it's important to note that the power was only introduced following the Conwert report. That was Lord Justice Conwert, as he then became, at that time a planning silk, who was asked by the then government to circulate a report on planning enforcement powers. And he said it should be placed in a statutory footing to ensure that it's a useful weapon in the planning armoury. There had been powers under the Local Government Act, etc., as well as part of the court's inherent jurisdiction to grant injunctions prior to the formalization in the statute of the power, but it was thought it would be better to set out that power with clear and defined statutory provisions. So that takes place, and very much the purpose was to allow the local planning authorities to have access to an urgent remedy where it was needed. So, for example, if there's a serious threat to amenity or the environment, for example, an authorised waste development, or equally where there's evidence of imminent residential occupation or of a harmful development taking place, and also to provide a stronger power where existing remedies have either proved to be inadequate or are likely to be inadequate. So if, for example, you have a site where there's been a number of enforcement notices served and they have not been complied with, a Section 187B injunction might be seen as an alternative, as a stronger remedy to try and secure compliance. It's quite clear that it's a flexible remedy, and of course that reflects the equitable nature and the history of injunctions. And that's also important to note that that equitable nature means that factors like delay, etc., will be relevant. So the court will need to take a broad view as to the equitable outcome in a particular situation, and it will look at conduct on both parts in dealing with the application. There are many different situations which an application might be made. So, for example, one might be faced with a breach of condition where a house builder or a developer is not complying with the conditions imposed on the grant of planning permission. For example, allowing occupation of units without offsite highways works having been carried out. One may also have situations in which, for example, there's a gypsy traveller development which has taken place without planning permission, or one may have operational development where a home has been constructed or outbuildings or stables, etc., in the absence of planning permission. In respect of what the orders can require, they can be either prohibitory or mandatory in nature. And what one means by prohibitory is they will restrain further development. So the defendant shall not undertake further development and breach planning control. The defendant shall not occupy any further units until the off-site highways impacts have been mitigated. The defendant shall not move any caravans onto the land, or alternatively mandatory, so direct specific acts be carried out. So the defendant shall remove the hard standing which has been laid on the land. The defendant shall remove the caravans placed on the land. The defendant shall install traffic lights at a junction with the local A road. Those sort of requirements. It's also important to note that obviously an application has to follow certain procedural timelines of filing and serving of the application and of evidence, etc. But where one has an urgent need, one can ask the court to make an interim injunction. And very much the purpose of an interim injunction is to preserve the status quo until the final trial. So if, for example, a number of caravans have been moved on, but the local authority is concerned that more might be moved on, an interim injunction can prevent that breach escalating, as it were, or spreading out across the land. So that can be a very useful remedy also. In respect to the actual or apprehended breach of planning control, it's important to note that the court will need to be persuaded by the evidence before it that there is an actual or apprehended breach of planning control. That will be a threshold question for the court. In many cases, it will not be in dispute. So, for example, it might be fairly self-evident if hard standing has been laid and a building has been erected that there has been operational development. In other questions, it may be more tricky. So, for example, if it's a material change of use, that may appear to be a slightly more tricky question for the court to determine. And it will have to reach a view on that question, even though it's settled law that matters of planning judgment are not for the court, and that in effect deference ought to be shown to the local authorities' views, as they are the authority who Parliament has decided is responsible for what development is or is not acceptable within a local area. Section 57.1 reminds us what development is. And while Section 171A tells us, of course, the development without planning permission is a breach of planning control, as is a failure to comply with a condition. So the court will need to be persuaded that one falls into some of those categories and demonstrates an actual or apprehended breach of planning control. As I've said, whereas a material change of use, that will require more cogent and compelling evidence to demonstrate by reference to established principles, such as the change in the character of the use, a change in the on-site or off-site impacts, the question of intensification, etc., as to whether or not there has been a change of use and why that is material in planning terms. So similar to the analysis one might expect to see in an officer's report, for example, in determining an application or in recommending enforcement action. That is the sort of evidence that the local authority will need to put before the court. Of course, in considering that question, it will be necessary to consider whether there's any extant planning permissions which have been granted in respect of the site, which might authorise the development which has been carried out, whether there's any historic lawful use rights, and indeed also whether the development has been categorised as permitted development or not. Because if the local authority gets it wrong, as it were, and it turns out there hasn't been a breach of planning control, that will obviously, apart from reducing the chances of success, as it were, in an application, potentially also lead to cost implications if people have been involved in defending the application. So it's something the local planning authority needs to get right. In respect of the legal principles, the leading case on this area remains the decision of the House of Lords and South Buckinghamshire District Council, as they then were, and Porter at 2003 House of Lords decision, in which the House of Lords endorsed the Court of Appeal's decision and set out a number of the important principles. The most recent, perhaps helpful case where all of the strands of the case law were brought together is Ipswich Borough Council and Fairview Hotels, Ipswich Limited, a 2022 High Court, 2022 rather, decision of Mr. Justice Holgate, as he then was. And that arose out of, if you might remember, a number of applications which were made in which local planning authorities sought to restrain the use of what had previously been hotels as hostels for asylum seekers, on the basis there had been a material change of use to use as an asylum seeker hostel without planning permission. There were a number of applications, the majority of which were unsuccessful in the High Court, and Mr. Justice Holgate took the opportunity in Ipswich to bring together all of the various principles, so it is commended reading. And what some of those principles tell us is the court will have regard to the fact that the need to enforce planning control in the general public interest is a relevant consideration. And in that context, the planning history of the site will be important. It also tells us that the degree and the flagrancy of the breach of planning will be critical. And that makes sense. The court is asked to grant an injunction, the consequences of not complying with which is a contempt of court and could potentially lead to committal, means that the court is going to want to have regard to the particular flagrancy of the breach of planning control before it. The case law tells us that where conventional enforcement measures have failed over a prolonged period of time, the court may be more ready to grant an injunction, and it may be more reluctant where enforcement action has never been taken. But all will depend on the facts of the case, and it's also quite clear from the statute itself that one doesn't need to have exercised the enforcement powers before seeking an injunction. But it means that particular circumstances are going to require the local authority to demonstrate to the court why it's necessary to seek an injunction as opposed to serving an enforcement notice in the normal way and potentially having that appealed. And some of the circumstances in which that might be appropriate may include whether there's sufficient urgency to justify the avoidance of an anticipated breach of planning control. So if caravans are going to be moved on to the site, well, it's all well and good to say you can wait for that to take place and then serve an enforcement notice, but that may result in landscape harm, it may result in environmental damage, potentially to ecology, potentially there's going to be an authorized waste or dumping, etc. Equally, it may be more preferable to prevent somebody moving on to the site in the first place, as opposed to allowing them to move on, then taking enforcement action, which results in them having to move after a long period of occupation, in which case the hardship and the impact on personal circumstances is likely to be augmented. It is important to note, of course, that, as I've said earlier, the local planning authority is the body democratically accountable for the enforcement of planning control and making of decisions. And therefore, it's not for the court to question the correctness of a planning decision which has been taken. So, for example, the refusal of a planning permission or the dismissal of an appeal by the Secretary of State through his planning inspectorate. But the court still has to come to a broad view as the degree of environmental damage, the landscape harm, etc., the heritage harm which might result from the breach, and also the urgency or otherwise of bringing it to an end. So it's very important, therefore, that the evidence sets out the planning harm, and that can be a potential weak point for local planning authorities if they haven't done their homework before making the application. With all of that before it, the court then has to engage in an exercise in which it weighs up all of the factors, both for and against the grant of an injunction, and balances competing interests before coming to a view as to where the balance lies. And there's a quote from Sad Bucks where it was said that the power exists above all to permit abuses to be curbed and urgent solutions provided where these are called for. Since the facts of different cases are infinitely various, no single test can be prescribed to distinguish cases in which the court's discretion should be exercised in favour of granting an injunction from those in which it should not. where it appears that a breach or apprehended breach will continue or occur unless and until effectively restrained by the law, and that nothing short of an injunction will provide effective restraint, that will point strongly towards the grant of an injunction. So will a history of unsuccessful enforcement and persistent non-compliance, as will evidence the defendant has played the system by willfully exploiting every opportunity for delay. Although Section 187B, subsection 1, makes plain that a local planning authority need not have exercised nor propose to exercise any of its other enforcement powers. So, bringing together the various strands in the case law, what does that tell us? Well, first of all, the local planning authority will need to set out in its evidence why it considers that an injunction is necessary or expedient, and why the other statutory methods of enforcement open to it are not likely to be effective. It also will need to demonstrate why it is necessary and expedient to take enforcement action in the first place, and why to do so ought to be by way of an injunction, as opposed to waiting for some of the other enforcement powers to be available to the local authority. It would also need to set out flagrancy and consider if there has been a flagrant breach of planning control. That will be demonstrated either by the behaviour of those involved. So, for example, the classic example of moving caravans onto a site over a bank holiday weekend with the prior submission on the Thursday evening or the Friday evening of a planning application, or alternatively, whether land is in an area of environmental sensitivity or an area subject to strong development control policies such as the Greenbelt. The decision at Ipswich tells us that can also be characterised as a flagrant breach of planning control. It will also be necessary to set out planning harm, so to consider the relevant development plan policies, the NPPF, and where relevant to PPTS, which is the planning policy for traveller sites, and other material considerations. Of course, that brings us down to the question of human rights and hardship. And again, this is a very important factor for the local planning authority to get right. The court, as we've said, needs to balance the public interest in enforcing planning control and planning decisions against private interests, which will be the personal circumstance of the defendants and the likely hardship which will be caused. And the court will need to consider whether it is proportionate and just to grant an order, considering, amongst other things, the impact on human rights. Of course, the hardship and the personal circumstances will depend on the case and those who are involved. So, for example, a case involving a commercial operator or a commercial development or a house builder will obviously give rise to different considerations to unlawful residential occupation in caravans. The first case will be concerned with the impact upon business rights, upon property rights, as well as the potential interference with those who perhaps are living in some of the development have already completed. Whereas the second case will obviously give rise to more pronounced considerations about impact, for example, on education, on a right to a family life and to a home, etc., etc. And what the case law tells us, and this comes from South Bucks, it was said that where an application is made to the court, the evidence will usually make clear whether and to what extent the LPA has taken account of the personal circumstances of the defendants and any hardship an injunction may cause. If it appears that these aspects have been neglected and on examination they weigh against the grant of relief, the court will be ready to refuse the application. Of course, if it appears the LPA has fully considered them and nonetheless resolved that it is necessary or expedient to seek relief, that will ordinarily weigh heavily in favour of granting relief, since the court must accord respect to the balance which the LPA has struck between the public and private interests. And that picks up on a theme, as I've said, where there's a certain deference shown to the role of the LPA and the fact that they are ultimately the body who Parliament has entrusted to supervise and enforce the planning control and the system of planning regulation. What the House of Lords also said in South Bucks is the hardship likely to be caused to a defendant will always be relevant to the decision on whether or not to grant the injunction. But in many, perhaps most cases, the hardship prayed in aid by the defendant will be of insufficient weight to counterbalance a continued and persistent disobedience to the law. There is a strong general public interest that planning controls should be observed and if not observed, enforced, but of course each case will depend upon its own circumstances. So in terms of practical tips, again, bringing together the case law, What that tells us is the local planning authority will need in its evidence to set out a full consideration and assessment of the likely hardship that will be caused and explain why, notwithstanding that hardship in those personal circumstances, and by reference to that hardship in personal circumstances, why the LPA considers an injunction to be proportionate. As a first step, however, that requires the local planning authority to fully understand and appreciate and be aware of the personal circumstances and the human rights implications. And indeed, one likely challenge against the LPA's claim will be if they have failed to do so, they fail to undertake adequate steps. So it seems to me that one way would be to serve a planning contravention notice, asking questions about those on site, or also a welfare questionnaire. Ultimately, if one just receives no reply to those, the LPA can say to the court, look, we have tried to undertake these assessments, we haven't been provided with the information, this is the best job that we can do. But if they haven't tried in the first place, that is likely to give some serious pause for thought to the court as to whether or not the order is justified. Of course, the other point that emerged in some of the most recent case law is it is necessary to keep the proportionality of a final order under review as the case progresses. So as more evidence comes to light, etc., as matters move on, as we move closer to the final trial, it's necessary for the evidence to keep up to date and up to pace with what we know. And the local planning authority will be required to demonstrate that it has kept welfare and human rights very much in mind, and it has assessed proportionality throughout the case, not just at the start of the claim. Other relevant considerations, again, depending on particular circumstances, may include the best interest of the child. Of course, that's not their primary consideration. It is a primary consideration, but it's something to be taken into account whether there are children residing on the site, and also the need, if relevant and engaged, to comply with the public sector equality duty. That will be particularly pronounced when a case involves gypsy or travellers, or perhaps occupants with disabilities or health conditions. That brings us then to more to practical tips, so in respect of interim injunctions. And it's important to note that where these are required, they can be obtained urgently. There's always a High Court judge who is available to hear even out of hours applications for injunctions. So applications can be put together and heard in a number of hours. Alternatively, they may be on notice or without notice. The general rule is that 3 days clear notice is required of an application. In some cases, it may be desirable to shorten that period, and one can still give notice, even informal notice, so for example, by telephone or by email, and ask the court to make an order that sufficient notice has been given. That is a different consideration to where one makes an application without notice whatsoever. And that's what's known as an ex parte application, where basically the only party in court is the local planning authority. There's very strict procedural rules, and the lawyers involved, be they in-house counsel, be they solicitors, or be they external barristers, will need to be satisfied as a matter of professional judgment that the ex parte application is justified. And what the case law and also the CPR tells us is that they can only be made where secrecy is essential, i.e. where taking steps to notify the defendants is likely to defeat the purpose of the application. So if, for example, one considers caravans are likely to move onto the land, the view might be taken that to give notice of the application would simply mean the caravans are brought on earlier than otherwise anticipated, so as to effectively achieve a fait accompli and defeat the purpose of the application. So that might be one case where secrecy is justified. It's important to notice as well that where one makes an ex parte application, there's an enhanced disclosure duty in the LPA. Because they're the only party in the court, they must bring all matters, whether they be adverse or favourable to the LPA, to the attention of the judge, and the judge will need to be told of any factors which might weigh against the grant of an injunction, in addition to those that do. And any failure to comply with disclosure at that stage, or any failure to, for example, even mentioned the possibility of human rights implications, can result in the interim injunction being set aside, potentially with cost implications, even if the LPA has a good case and even if they're likely to obtain a final order. So it's very important that where the local planning authority is considering an interim injunction, they approach their solicitors and their external barristers as soon as they can to ensure that all of the boxes are ticked, as it were. The purpose of an interim injunction is normally to hold a ring pending the final trial, so to prevent, as I've said, breach escalating or getting worse, to prevent further harm from occurring. So the restrictions will normally, for example, prevent further disposal of land interests or further residential occupation, etc. Normally, they will only contain restraining elements. That's not an absolute bar, for example, and indeed very often the elements might be considered to be an intermixture of both. So, for example, a restraining element to prevent one from carrying out a further unauthorized use, for example, unauthorized car parking, for example, might also be interpreted as a mandatory element not to carry out the business on the site, etc. So sometimes the picture can be a little bit more nuanced than might appear at first glance. As I've said, the American Salamine principles had to be applied at the interim injunction stage, so it will be necessary, therefore, in accordance to procedural rules, to apply to the High Court. What the court will have to do is apply the three limbs of the American Salamine test, which remains the leading test. It's a 1970s decision, remains the leading test for interim injunctions in any area of the law, not just in planning law. But what it says is there is a serious question to be tried. So what that means is there an arguable case on the evidence before the court that there has been an actual breach of planning control, or there's likely to be an actual breach of planning control or an apprehended breach of planning control? Generally, at the interim injunction stage, that will be almost taken as a given. The application is unlikely to have got that far unless there's likely to be a serious question to be tried, but not always, and it will depend on a particular circumstance of the case. And very often defendants will tactically acknowledge there's a serious question to be tried at the interim injunction stage to avoid further argument at that point, but without prejudice to their position at final trial that there has not been a breach of planning control. The next question will be, are damages an adequate remedy? And what the case law tells us is that unlike, for example, in commercial cases, damages are not an adequate remedy for the LPA because what they are seeking to do is to enforce planning control. And indeed, Mr. Justice Holgate in Ipswich said it was hard for him to see how damages could even be an available remedy, let alone an adequate remedy. If there's a breach of planning control, that cannot be adequately compensated by the payment of money to the local planning authority. And the other point, of course, is that generally applicants for injunctions are required to provide a cross undertaking in damages to the defendant, i.e. if it turns out later that I should not have obtained an interim injunction, I will be required to compensate you for the financial loss you have suffered in the interim period. There's very established case law, which again says, and it has been applied successfully in the context of planning injunctions, that where one is a local planning authority acting in the public interest, it would not be appropriate to require a cross undertaking in damages. The third limb of the American Salamine test is, where does the balance of convenience lie? And again, what this requires the court to do is weigh up the pros and the cons of granting an interim injunction to decide where does the balance of convenience lie, i.e. in favour of granting an injunction or not. It's important to note as well that where an interim injunction is granted without notice, there will generally be a return date hearing listed for 7 to 10 or perhaps 2 weeks after the first hearing, and which the defendants will be able to come on notice, and the court will be able to decide whether or not to continue the ex parte injunction. It's also necessary to consider at that stage whether there are any other related applications. So, for example, for applications for alternative service, so there's a large number of defendants, or person is unknown, or there are likely to be difficulties in effecting service, one might ask the court to make an order for alternative service, for example, service on the site by fixing it to conspicuous locations at entrances to the land, etc. One might also need to consider an application to dispense in those particular circumstances with a need for personal service. That is relevant because under CPR Part 81, where one is dealing with contempt and committal applications, you will need to say to the court whether or not there was an order dispensing with the need for personal service. Generally, the rule is orders have to be personally served. So again, it's important to take early advice on all of these procedural issues. That brings us down to persons unknown. And as we saw earlier when we started with statutory provisions, Section 187B, subsection 3, tells us that a rules of court may provide for such an injunction to be issued against a person whose identity is unknown. And the relevant rules of court do so. Now, there's two categories of persons unknown. The first is whether protagonists are unknown. So, for example, you've had works carried out, and it's simply not possible to identify all of those parties or entities involved in the operational development or in the unauthorized use. The second category is where one is seeking to restrain newcomers, so those who might seek to move onto the land in the future or to engage in authorized use. And it is the latter category that gives rise to the most difficulty or concern for the courts. Because in the first case, once notice has been given, those protagonists have the opportunity to identify themselves and come to court. The second case is more difficult because, of course, in those circumstances, these are people who may not even be aware at the moment of the land or of the proceedings, and their interests are not going to be represented in court. So it is for that reason that the Supreme Court 2 years ago in Wolverhampton City Council and London Gypsies and Travellers set out very strict procedural and substantive rules which are to be applied where persons unknown are gypsies or travellers. The local planning authority will need to demonstrate, amongst other things, a compelling need for the injunction, a strong possibility of a breach of planning control, as well as territorial and temporal limits on the injunction. So it's unlikely, for example, that a person's unknown injunction in such cases will be granted for longer than a year without that needing to come back before the court for a review. Again, with respect to territorial, there are strict territorial limitations, and that arises in the context of concerns about the extent and scope of what are effectively borough-wide junctions. There are also very strict procedural requirements relating to, for example, notice and consultation, so making sure that those who are likely to be affected by the order and by the proceedings are given notice and have the opportunity to come to court, etc. Consultation with those who might be able to represent the interests of those affected by the order, and also strict provisions which require liberty and generous provisions as to liberty to apply, etc., and to be able to come back to the court to seek a variation or amendment of the order. That brings us to the end of our whistle-stop tour, as it were, in Section 187B injunctions and the various procedural and substantive matters that they raise. That's an opportunity to hand over now to questions. As it's an online webinar, and the most appropriate way, I'm told, is to provide questions in the chat box. Deirdre from Chambers is also on hand to assist and pass any questions to me if they don't come through the chat box function. But I'm happy now for you to fire any questions that you might have into the chat box. If there's no questions, that's a sign I've either done a very good job, or alternatively that I've bamboozled you with so much information at once that it's all of it heavy for lunchtime. But please, if there are any questions which arise afterwards, feel free to send us an email and we'll make sure to help you with those. So I'll leave the chat open for another couple of moments if anybody does have any questions they'd like to ask. Thank you, Sarah, and Danielle as well. Yes, so Sarah's asked if an enforcement notice has been served but ignored. Could we then apply for an injunction? And the answer to that question is absolutely. So the case law, and there's extensive case law, for example, Chelmsford and Mixture, which is the case I was involved in last year. There's also an Epping Forest case that talks about the circumstances in which the local authority has tried to enforce against breach of planning control with an enforcement notice and it hasn't been followed or complied with. In those circumstances, the courts have said, well, yes, the local authority may reasonably form the view that the only option really now to enforce the enforcement notice and to secure an end to breach of planning control is an injunction, because of course the consequences of not following, as we've said, an enforcement, an injunction is where one says that you can be potentially committed to court for contempt. So it tends to rather focus to mine. So the answer to your question, Sarah, is absolutely. If enforcement notices have not been complied with, you can seek an injunction from the court to secure an end to the breach of planning control. Stephen has also asked, can an application for an injunction be warranted in the case of a breach of planning condition? The answer to that is absolutely, it can. So a breach of a planning condition is, as you know, a breach of planning control, amenable either to a planning enforcement notice or to a breach of condition notice. But an injunction can also be sought. And to give you one example of a case I was involved in, a national house builder, and I acted for the house builder in that particular case, had not carried out the highway works which was required by a condition imposed in the grant of planning permission. And in that case, the local planning authority sought to seek an injunction to prevent further occupation of the units until those works had been carried out. So that's one example of where a condition gave rise to an application. I think what that really does show is the versatility of an injunction and the many different circumstances in which it can be used. But no, the answer to your question, Stephen, is yes, absolutely yes. Matthew has asked, if there has been a breach of an injunction and application for committal is made, is a custodial sentence the most likely outcome, or might a fine be considered? So yes, so where one has committal, there's a number of options open to the court. They can either send you to prison, they can impose a financial fine, or they can also order the confiscation of assets. And what the likely outcome will be will depend on a number of factors. So, for example, whether or not the defendant comes to court and attempts to purchase their contempt, if they apologise to the court, that can also be a factor why the court won't send it to prison. Equally, the court might take the view that a fine is likely to send a sufficient message as to the court's disapproval of the contempt of court, and indeed against companies, that can very often be the most likely outcome. But there's no reason why, for example, directors can't be committed to prison if they are responsible for the breaches of the injunction carried out by the company. The situation in which imprisonment would often be where there's been persistent and willful and ongoing failure to comply with the injunctions. So courts do tend to sort of take a lenient approach, not the right word, but if they're persuaded that, okay, there has been breaches of the injunction, but that's not likely to take place in the future, they may decide at that stage that it's not proportionate to send a wrongdoer to prison. But if one came to court, said, I won't do it again, and then proceeded to breach the injunction again, that would be a case in which imprisonment would be likely. So again, it all depends on the particular circumstances of the particular breach of the injunction as to what remedy the court is likely to impose. Harjeet has asked whether it's a breach of an injunction and committal, and the defendant seeks to amend the injunction to allow further stationing of caravans in breach of the injunction following a change of circumstances, would it likely that the amendments would be refused where child needs are under consideration? So again, I think it's very fact-specific question. It would depend on what the particular evidence as to the needs of the children were and what view the court took about that. But of course, where an order has been breached and further occupation has been allowed, the court will need to take a view as to whether or not that was a breach of the injunction. And seeking to amend the order post breach might be seen as a rather cynical attempt to try and downplay the contempt that has taken place. The other important factor to note, Harjeet, in your particular circumstances in that question there, is that very often, because the courts are mindful of children, etc., very often the residential occupation, it will be those who are responsible for it, i.e. those who allowed children to move onto the site, who will be responsible for the breach of planning control and the breach of the order, and who would be likely to face imprisonment. An injunction in that way is not going to be able to be enforced against a child. It's going to be enforced against those responsible for the bringing of the further residential occupation into existence. But a very good question. But again, it will depend on the particular facts and circumstances. And yes, the application to vary will need to be able to show a material change of circumstances to seek to persuade the court why it's appropriate to vary the order after it has been granted. And here's another great question from Stephen. In the case of an injunction covering a wide area with restrictive elements, where planning permission is granted for a portion of land within that area, do the restrictive elements remain in force for the remainder of the wider area? Again, it will depend on the way in which the order is drafted. And very often what the order will say is the defendants must not, without planning permission, carry out any further development, etc., must not station caravans on the land. So yes, so if, for example, a small portion of the site had been afforded planning permission for a certain amount of residential caravans, obviously it would not be a breach of the injunction to station caravans in that part of the land. But that wasn't discharged or removed unless the order was worded in that way, the restrictive elements or indeed the mandatory elements which applied to the rest of the land. And indeed, the injunction in respect to the part of the land for which planning permission had been granted would only be disapplied to the extent planning permission had been afforded or granted for that particular use. So if, for example, planning permission was granted for the station of a caravan, and in fact, further operational development unrelated to the station the caravan took place, that would obviously be caught by the restrictive and restraining elements of the order. So again, it would depend, as I said, on the way in which the order is granted, but most likely the answer to your question would be yes, Stephen. And again, there's also the question of where there's been a temporary permission granted, for example, as the interplay with the order and whether or not it might be suitable to vary the order. So if, for example, it had said the mandatory steps must be only complied with where planning permission is refused, let's say there's an ongoing appeal, if a temporary planning permission has been granted, it might be appropriate to ask the court to vary the injunction so the mandatory steps kick in, as it were, at the end of the temporary permission if that was granted for a number of years. Or equally, if it was a personal permission, if the individuals concerned were to vacate the site. These are all excellent questions, so please keep them coming. Well, if there are no further questions, and if there are, please turn them into the chat box. It remains only for me to thank you very much for coming to our webinar. I hope you found it a useful and informative afternoon, and thank you for giving up your lunch hour to join us. As I said, if any other questions arise after, please feel free to drop either myself or Chambers an email. I will endeavour to reply to you. Also, as I mentioned earlier, we have a discount code available if you want to purchase the book online, and I'll also make sure that in addition to the slides that we circulate the discount code afterwards. There is one further question as well from Sarah, just the timeline matter. And I suppose, Sarah, that's probably tied to your earlier question about the non-compliance enforcement notices. As I said during the course of the presentation, it's an equitable remedy. So in some cases, the local planning authority had sat in their hands, as it were, for an considerable period of time and had not sought to take any action. The defendants might rely on the equitable defence of effectively acquiescence or delay and say, well, look, the local planning authority has left this far too long, and that's a fact that the court should take into account in exercising its equitable jurisdiction. So unless the council had had good reason, for example, they said, well, look, we had an enforcement notice, it was 18 months for compliance. We spoke by way of letters, etc., for a couple of months after the 18 months had expired. That would be a good basis for going to the court. If it had been several years and no action had been taken, it might be slightly harder for the local planning authority because the court, the defendant might say, well, the delay here has been inordinate. But of course, on the other hand, the local planning authority might say, well, yes, that's true, but there is harm occurring here. There's environmental damage, there's landscape harm, etc. So notwithstanding the delay, an injunction ought to be granted. So again, all will depend on a particular circumstance of the case. And what you can see from that example is that these arguments can be run either way, and it will all depend on the particular difficulties and circumstances. But it's best not to delay, because as I've said, that makes it likely that there's a potential for the defendants to say that the local planning authority has left it too late to seek an injunction. So where the facts arise, either be it a breach of planning control or be it a failure to comply with enforcement notice, it is better to go to court sooner rather than later. Excellent. Well, thank you all for your really informative questions and your engagement this afternoon. It's been really, really helpful for that. So thank you very much indeed. And it remains then for me to wish you all a very good afternoon. Thank you for joining us.